My lord, I may be excluded to mention, my lord. I want VC, my lord. Item number 22 of the duty list, my lord. I will take 2 weeks, my lord. Item
Item
22.
item.
22, my lord.
What do you want?
I want 2 weeks time, my lord. After 2 weeks.
It is list. Don't worry. It will remain.
My
And
lord.
get ready.
My
This
lord.
is 2001. It's all right. We'll take it up.
I am not a word, my lord. That is why I am.
It's all right. Let it be there in the list. I'll take it after 2 weeks. No problem. Okay.
My lord. Obliged, my lord.
Okay. Yes.
Item 8.
Your Lordship, it's a criminal appeal filed under 374(2) of the
File then.
Your Lordship. Over there, the appellants, there are two appellants, Your Lordship. Both were charged under section 366 and 376 of the IPC. And
there are two. One appeal or two appeal?
One appeal, Your Lordship. However, appellant number 1 was convicted under both the charges, and appellant number 2 was only convicted under 366 of IPC.
You can. Detail copy. You have paperwork, Mr. Pandri?
Yes, sir.
You have paperwork?
Yes, I collected the
Same paperwork, na? Give it to Mr. Pandri. It will be easier for you. Extra copy is there, so we can use. Yes. Yes, madam.
The allegation.
So this is then 8 years.
8 years imprisonment for appellant number 1 with 500 rupees fine, and for appellant number 2, 3.5 years of imprisonment and 500 rupees fine.
Vishwanath is
appellant 1.
A1, 8 years. Okay.
Yes.
And who is second?
The wife of Nath Khamari, Arati Porida.
3 months and so Arati Porida.
Yes, Your Lord.
Arati Porida is A2.
Yes, Your Lord.
A2.
3.5.
3.5 years. Okay.
So the allegation was that both the victim was very disturbed in her marital life. She left the house, and she was actually thinking whether she wants to go to her natal home or not. She was on the roadside. Arati Porida saw her on the way, and she spoke her heart out to to appellant number 2. And then appellant number 2 told her that, okay, I'll take you with me to my house and I'll give you work. And that's how both of them came in contact with each other. They did not have any prior communication or prior acquaintance with each other.
And she took her to her house.
Yes.
Okay.
And thereafter they both started residing together. So, but the issue is, from the very beginning, there were my humble submission is there was no force at all. There was no compulsion. Arati Parida was very clear from the beginning regarding her intentions that she wants to find her work. And even the parents of the victim knew what the victim was getting. And that is...
There's no kidnapping, element of kidnapping.
No kidnapping, there's no abduction, nothing at all.
Yes.
And that is very much... For that, Your Lordship, I request Your Lordship to come to page number 41, Your Lordship, of the paper book.
Yes.
Over there.
That is
that is PW1, the father of the victim.
Father of the victim, okay.
And Your Lordship.
Victim, okay.
Your Lordship, PW1, that is the father, the only evidence, or his deposition is the only evidence which has supported the victim's case.
Okay.
Throughout the entire prosecution, there is no medical report supporting that there has been a sexual assault. There is no corroborating statement. Okay, there's no statement of any other witness which corroborates the statement of...
Who is the prosecutrix? Victim? PW2.
PW2.
Let us read first. Informant is the PW1.
No, PW2 is the...
Let us read PW1 first. Then you get an idea. PW2 one.
Okay. So, Your Lordship, with respect to, I'll first examine ingredients of section 366 first. For that reason, I beg to draw your attention to page 45.
That is PW2.
PW2.
Let us read the evidence to the. Let us understand what exactly.
Okay.
Surendra Behra
Surendra Behra,
is my father.
PW1.
Surendra Behra, PW1. Yes.
Is my father. I know both of the persons. One of them is Arup and the other is Vishwanath Khamani. I had no previous acquaintances with the accused persons prior to the date of last Ganesh Puja. On the day of Ganesh Puja, I left my husband's house in search of work. I came with my little daughter. I was walking on the road in front of Waliganj school at about 2 p.m. with my little daughter on my lap. Arati was returning from work on the road. I sat on the road to decide whether to go to my mother's house or somewhere else. Arati came near me and asked me where I was going. I told her that I had come in search of work. She told me to stay with her and assured me that both of us would work and live. I believed her and went with her.
I believed her.
I believed her and went.
And, yes.
To the house of the person where she was working. Thereafter, we came to the house of Arati. Arati and her son, aged about 5 to 8 years, were living together. My parents met me on the road. I brought my father and mother to the house of Arati.
Okay.
My parents told Arati to keep me and to take care of me. My parents promised me to provide rice, etc. living. My parents went away. I stayed in the house of Arati during that night at about 6 to 7 p.m. After approach of night, accused Vishwanath Khamari came to the house of Arati. Arati asked me to cook food.
Who is
He went to-
Vishwanath? Arati?
Husband.
Husband.
Yes, it is.
Wife
said-
and husband. Okay.
Yes.
Arati asked me to cook
Arati
food.
asked me to cook food and went away with the accused for hours together. Thereafter, we slept after taking our meals. During night hours, Arati told me that she would engage me as maid servant and asked me to keep her word. Arati told me to earn a huge amount of money if I would go to the lodge. Told me to stay in the lodge for the night, bring money and to live together happily. I refused her to work in that line to earn money. Thereafter, she consoled me by saying that she would arrange work for me in case of
suffered disqualification attaching to a conviction. Dear, Section 12 protects you.
Yes, sir.
I'll record this part also. I'll record this part, Mr. Panning. I'll record if he gets some benefit, why not? Huh? I'll record this part. And what is the other judgment you are relying upon?
Other judgment is that is your lordship judgment.
We will give. No problem.
That is the your lordship.
No problem. He's working as what?
Postman.
Huh?
Postman.
Postmaster.
After retired.
No, some pensional benefit, something he may get.
That use of that judgment.
He was working as postmaster.
Yes.
Statutory provision.
Postmaster. You asked for that provision before the trial court, which was refused, huh? Para, which para?
Yes, refused, no, the last one. Hearing on sentence para. Case eight.
Ah, yes. It's only 498, na?
Yes.
Okay.
Other one district.
Okay. I'll record that part also. Justice Chandrachud's judgment. There is a statutory backup, section 12, but that is again interpreted by Justice Chandrachud, so that will help. I'll record it. इसको दे देना. ठीक है. Okay, then at 12:30. Who else is that ready? Which one? Item? 70? 72, 2010. 9, huh? The old matters, focus on old matters, yeah. Nobody is doing old matters. 9, 95. Ready? 95 will do. 95 will do. Item 9 first will do. Yours also I'll do. Don't worry. Small matter I'll do that. But 9, let us focus on 9. 95 matter. Anything, Mr. Ponda, you just take it up when you POP question, Mr. Ponda. Okay. Okay. Everything. Okay.
May it please your lordship. I'm
Right.
appearing on behalf of appellants pursuant to the previous order dated 16/12/2025. I've prepared a chart of injured witnesses.
Okay. How many appellants?
11 others.
11. Out of them, anybody died? No.
5 and 6.
7, 6.
5, 6 died.
Yes.
5 and 6 died. Admitted already.
Yes.
Yes.
Five.
And order dated 10/7/2020.
10, 7,
2020.
20.
Yes.
Okay. Yes, this is the chart you said.
Charges were
PW2, accused person's name as an assailant. Huh? Conjury boy A. Conjury boy is which appellant? Not appellant.
Saran Panjal
Saran Panjal appellant 1.
A1, huh? Okay. And who is Biswa and Kunu? Biswa is
Kunnu is 8.
A8. And Kunu, sorry, Biswa 8, huh? Kunu?
Your lordship, Kunnu is 8.
Acha, Biswa?
Vishwa is not there.
So is not.
Not there. Acha. And Panjara A1.
A1.
ठीक है. And Panjara A1. Panjara B. Siddharth?
Sridhar is 3.
Sridhara?
Yes, 3.
A3. Gokula?
Gokula is 6. He is abated.
A6.
Straight.
And Sora?
4. 4.
A4. Sajit?
11.
A11.
10.
10.
Your lordship.
A10. Sonoda?
9.
9.
A9. Bas. This is how the story goes. And who all are not named by anyone? A4, A4 name.
A5 is
A5.
A5.
A5 and 6.
Both paid.
6 is named.
6 is
7.
7
7 also not named.
not named.
A7 not named.
Named.
Okay. What about 2? 2 also not named. Isn't it?
No, Your Lordship.
2 is not named.
Not named.
9 named. 1 named. 2, 3 named. 4 also named.
10.
5 not named. 6 named by 1. 7 by none. Okay. 8. 9 also name. Let's see. Total 11, huh?
Yes, Your Lordship.
Total 11. So 2, 5 and 7 not named by anyone. ठीक है. 2, 5 and 7.
Yes, Your Lordship.
You've checked it. Now let us come to the facts. Yes.
Yes, Your Lordship.
You're convicted under 147, 148, 324.
320. Read 149.
Two years and to be fine of 1,000.
1000.
6 months. Yes. Are you aiming at an acquittal
Yes.
or I'll give you PO?
Quittal, Your Lordship.
Acquittal, these 3, 2, 5 and 7.
5 and 7.
They will be acquitted because nobody has taken their name.
Yes.
And the rest I can give PO if you want. अभी मेरा उसमें जजमेंट मेरा टेबल पे ऐसा रखा हूँ. Just get it. Get that.
Yes, Your Lordship.
Go to my table. That recent judgment, Chelamal judgment, that he might not be knowing. Have you seen Chelamal judgment? Justice Dipankar Datta's judgment. You can utilize that judgment. You can utilize the judgment. So if you want, I can give PO to the other remaining people. Out of that, two of them have died. 5 and 6 have 5
and 7.
5 will be 7. 5, 6 died.
6.
6 died. Then 1, 2, 3, 4. 2 will be acquitted. 2 will be acquitted. 7 will be acquitted. And the rest of the other will be, though convicted, but will be extended the benefit. Yes. If you are aiming at an acquittal, let us see who all are the injured. All the witnesses are injured, na?
No, only mentioned in the chat.
Injured 2,
2, 3, 5, 6, 7, 8.
injured
5 to 8.
2,
3.
injured. Yes.
And 5 to 8.
5 to 8 all.
5 to 8. 5, 6, 7, 8. Yes, Your Lordship.
So they're all injured, na? All injured witness.
Lordship, the accused persons are also injured.
Accused persons are also injured.
Injured.
They were
All of them.
They were examined by the doctor.
Yes. PW4 and sorry, DW2. Both sides, same doctor.
Okay. Let us see. Let's come to the one of the injured. And which of out of all the injured witnesses, anybody has said regarding injuries being sustained by the accused persons?
Pardon your lordship, sir.
Any of the witnesses have whispered about the injury sustained by the accused persons?
No, to prosecute.
Prosecution has explained it.
No, they haven't. No.
And
Yeah.
the IO had taken the accused person to the hospital for testing, or
Yes.
IO has taken.
And IO has also mentioned that the prosecution has also not mentioned the same thing to IO.
Let us see which part.
Hmm.
Because there is a judgment, my judgment only, where I have said that if there is a fight between two groups, and particularly 148, 149 and all, and the accused persons have sustained injury, the prosecution has not whisper about it. Rather, the defense evidence, through defense evidence, they have brought that part of the evidence that they themselves have received injury. Then, but for the silence regarding the injury not explained by the prosecution, you are entitled to an acquittal. So that part you have to show me. PW, IO,
Yes, PW 12.
12.
Running
Page
page
1.
131.
Now let us see. What does it say?
Running page 131 of the paper book, last para. To
Let-
quote.
To quote,
I could not.
I could not ascertain from PWs as to how the accused person sustained.
1 minute.
Yes, Lord.
PW 12. I examine PW. Which one? Which para?
Running page 131.
Last
Para
paragraph.
5. Subpara to quote.
Okay, to quote. Okay.
I could not ascertain from the PW as to how the accused person sustained the injuries during the occurrence. Prior to this case, I had also investigated case and counter cases. Although I was aware of the fact that PW is not explaining injuries sustained by the accused persons during the occurrence would amount to material suppression, I did not mention those facts in the CD as the said episode is likely to go against the prosecution.
Then it is. Where is that judgment? My judgment, find out.
No, there
Come.
is another decision of the Honorable Baptist Court also. There are three things.
So,
Pursuing mechanism, para 70. Prosecution failed to explain the injuries and person of the accused.
Hmm.
There are three consequences.
para.
70.
Yes. Situation like this.
Yes.
When the prosecution fails to explain the injuries.
And person of an accused, depending on the facts of each case, any of the three results may follow. That the accused had inflicted the injuries on the members of the prosecution party in exercise of the right of self-defense. It makes the prosecution version of the occurrence doubtful, and the charge against the accused cannot be held to have been proved beyond reasonable doubt. It does not affect the prosecution case at all. So, in all cases, it is not fatal to the prosecution case. Now, in this case, no cross-examination, not even suggestions were given to the witnesses that they exercise the right of private defense. And not that injuries are also not serious, or simple injuries. And here the injured person, several injured persons, more than 6.
So it is a, what is the defense taken by these
They have
accused persons?
that it's a false case. In 313
No,
statement.
false case is one thing, and who is the aggressor? Anything of that sort is coming.
They went to
Let us see
that
PW.
place.
Let us see one suggestion.
PW9 is an independent witness to occurrence of loss and belief. PW9.
No, PW8 118. Just see page 118.
Minor.
Let's see. It says cross examination. It is not a fact that we assaulted the accused persons. when they came to our place to call to go for a meeting, and not the exactly words uttered by the accused persons while coming near our house. Accused so and so, so and so, so and so, not sustain injury during the occurrence.
Then in the counter case, you have also stated that the.
I cannot say if the accused person has assaulted me and fell down so and so. So this is what the suggestion is. Accused person so and so have not sustained injury, whereas the IO says sustained injury. Let us see 7.
It is not correct in view of the evidence of DW2. The doctor stated that the appellant Sarat Roi, Sridhar Roi, and appellant number 1, Sarat Hon'Ble Roi, they have all sustained injuries. Gokul Roi, all simple injuries, but
No, simple injury or
Roi,
injury is not more important. Important is whether they have sustained injury or not.
Yes, Your Honor. You must have an exhibit A to E is mentioned in the judgment.
1 minute.
Medical reports, sir.
from the evidence is right between two groups.
That's what. Right between two groups. Come to page 108. Signation PW5 in between. I cannot say if the accused persons came to our fora and to call C to a meeting. It is not a fact that just prior to the occurrence, we all were heavily drunk. And it is not a fact that when the accused persons called us to attend the meeting, we attacked them with lethal weapons and cause injury to their persons. And it is not a fact that the harmed Tangi assaulted by the so and so, so and so. It is not a fact that we have assaulted the accused persons, causing injury on their person. I cannot say if the accused persons so and so, so and so. These are the suggestions. Next, come to 4. PW4 is the doctor, huh?
Yes.
Page 98. I have not noticed any injury on the person of the accused person at the time of the occurrence. I saw him pass in so and so 15 days after the incident at the village. He also not noticed any injury on his person. Then the accused persons have not instituted any case against me and my caste man on the allegation that we assaulted them on the date and time of occurrence. It's not really on bail so and so. So the all the injured witnesses have actually said that no injury is caused to them.
That is incorrect.
No injury is caused to them. Whereas IO says he could not ascertain from the PWs that how these people have sustained injury.
As well as DW, the same doctor examined the injured accused.
DW2. He says the injury is serious. Then what will we take then?
There were fights between both the groups. But they visited that place. They went to call those persons.
Your Lordship, in a recent judgment of Sri Chikkegowda and others versus State of Karnataka and others, 2025 INST, it was held that if the contradiction between ocular and medical evidence is so extreme that the medical
No, you are missing the point where we are deliberating upon. What we are deliberating upon? Tell us.
that
We both of us are trying to find out a way for you.
okay.
You tell us what is the point? What is the point? He has shown a judgment. Have you seen the judgment? See, the witnesses have said, the injured witnesses have said that the accused persons have not sustained an injury and no case is registered, cross case is registered and all. That's what their case stand is. The fact remains that the accused persons have sustained injury because of DW's statement. And the IO says that I could not ascertain from them. So in the face of this kind of evidence, the judgment cited by Mr. Pai and one of the judgment I have given, what is that judgment?
Yes.
Where it says that if it is not explained, if the injuries are not explained, then you are entitled to an acquittal. And if benefit of doubt, but if the injured persons are saying that you have not at all sustained the injury, in that case, what will happen? And the case which I have written the judgment. There I have said that there is no whisper about whether injury was sustained or not. But here the witnesses have said they have not sustained injury. It may be a case of self-inflicted injury. That's what he cites the judgment. If you are remaining silent one issue, if you are not remaining silent, and you are saying that yes, they have not sustained injury, and the IO says that I could not ascertain, but the factum of injury sustained by the accused was there. Whether they have received or not is a different story. But the other case which you are going to cite, in that case, the factum of injury was not borne out from the evidence of the prosecution at all, as if nothing has happened. Then it went unexplained. Properly explained, unexplained. There are two different stories. It is not properly explained, but the factum of injury being sustained by the accused persons has come on record through the prosecution evidence. It may not be satisfactorily. So therefore, in that light of the facts which is borne on record, how will you appreciate this judgment, this Gujarat judgment in Supreme Court? 75 judgment and the one which I have written. Just see, check it up. Read the operating part.
Lakshman. Okay. Yes, Your Lordship,
If
your
you
judgment-
can bring your case within the purview of two only, it says it makes the prosecution version of the occurrence doubtful and the charges against the accused person cannot be held to have been proved beyond all reasonable doubt. You have to bring your case within the bracket of that exception. Then only you can take the benefit of the judgment. Otherwise, the first exception and second, third ones, nothing.
And there is medical evidence also examined by the trial court. To sustain in exhibit say A and D, they have stated that the prosecution side has given injuries.
Hmm?
In the injuries sustained by the accused persons in exhibit A to E in the medical.
That I am agreeing for it, but how the injury has caused? And the prosecution was not silent. Prosecution also says the witnesses say they have not sustained injury, but the IO says the factum that the injury sustained by the accused person is coming on record. It's not a complete silence. Now again, the appreciation of evidence insofar as the DW is concerned, that is again we'll see whether you can take the benefit of that judgment.
Also with this type of cases, but the benefit of doubt is usually given to the accused
Why?
based on
5, 6 injured persons are telling that they have these people have attacked very meticulously. It is a village and everything is happening, and you have not filed cross case. Where is your cross case? If you have sustained injury, you should have filed a cross case. You have not filed cross case. Therefore, it can be said to be a self-inflicted injuries are also. Come to DW1 defense. Who is DW1? Na?
DW1
defense.
DW1 is evidence so that these people tend to.
DW2 is doctor.
DW2 is DW1
Let us
is
see
another.
what kind of injuries.
hardship in DW1.
1 minute. Who he is examined? Sarat Voi, injured Sarat Voi. He is A.
Abrasion.
No. His appellate number
Sarad who is
Appellant number 2.
A2.
A2.
A2. ठीक है. He has sustained simple injury. Yeah. And Sridhar
Sridhar is appellant number 3.
A3 sustained 2 injury. All simple injury. ठीक है. Lacerated. Average. One lacerated, one average. ठीक है. And PW and Saran Panjar Voi
Appellant number 1.
A1 lacerated, average. Simple. Gokul Bhai
A6.
A6.
Lordship, he has suffered the maximum. He has suffered the maximum. Of
3 injuries, 4, no, 5. 5 injuries. All injuries are simple. Sujit Bhai
A12.
A11.
12, your lords. 12, your lords.
Huh?
A12.
A12. A11 होगा ना?
A11 is Ajit. It's
How many appearance total?
11.
So Sujit Bhai
Sujit Bhai
11. Why are you confusion? And these people were police requisition. Under police requisition.
Yes.
And now he says, I can't explain. Are you?
Yes.
IO says. What is IO says? PW4. These people have sustained. That's right. Urmila is PW?
Yeah.
Just check it up, tell me.
PW3.
Urmila is PW?
3.
PW3. Urmila, PW3. PW3. Same day. Simple. Ramesh?
Ramesh is PW7.
PW7. PW7. Received injury following injuries. Injuries are simple. And Sudarsana, PW6. 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 Simple in nature. Dasarathi, PW2. Reserve. Ajodhya,
PW8.
PW8. This is simple. Bikolo,
PW5.
PW5. PW5. Simple. Okay. Then insofar as PW or 2 is concerned, he has sustained 3 injury. The nature of injury was not disclosed by this doctor, PW4, saying that he has reserved it a further opinion from his specialist. All other witnesses have received only simple injuries as far as PW4 is concerned. Yes. Yes, Mr. Panikle, how will you respond to it?
Then some PW1 videos they went, these accused persons went to their class. And there was a class between both the groups.
No, now see, there was a class. This is coming, apparently there was a class. But all the prosecution witness says that the cross-examination says that they have not sustained an injury. Then how will you say?
So,
This case have benefit of doubt.
So Lordship in DW1, para 2, has stated that the aforesaid 5 accused persons went to Hasapara without any arms with them. No meeting.
You have also received simple injury. They have also received simple injury. And for some flower garden was
Started from there.
started from there, and there is fight between both the groups. And where is that judgment? So give me the one which I have my judgment. Give the printout.
I will get the printout.
I will give it to you. Okay.
Lordship, in another case also, in Pradeep Kumar versus State of Chhattisgarh, it is stated if there is possibility of 2 views, then the one favoring the accused, as you stated.
That is a fundamental principle. If there are 2 views are there, then the view tilted in favor of the accused has to be given. There. Appearance. Huh? Thank you. Any other matter? Yes.
File a note. File a note.
Note by tomorrow.
Yes.
Any other matter to be Wednesday?
72.
Huh?
72 voters.
72 will do. Lunch for it.
Deepak Bhava is there. So whether he is coming or not, I don't know. I am the co-accused. It can be taken up on Tuesday.
Next year, I will visit.
Koribe, nothing got. Send
Told.
72.
What is it? Five zero?
50.
Yes. Yes.
That's if your conviction under 324 IPC for 6 months, Your Lordship.
Hmm?
Your conviction under 324 IPC, Your Lordship. And for 6 months, RI.
6 months.
19 days already period under.
Hmm?
19 days already period under.
19 days undergone.
Hmm.
19 days undergone. ठीक है? Okay. So total sentence is 6 months.
6 months. For 324 IPC. 324 IPC.
324.
Yes.
These 307 not found guilty. 324 found guilty. ठीक है? So I'll give probation.
Very low.
Probation I'll give because as good as acquittal. Probation, huh? PO. 19 days undergone.
Lordship, I don't have power in this case, but it is our chamber's matter.
I'll appoint you as an right on. Right on. This appeal is pending since 2009. When the matter is taken up, none had appeared in the earlier occasion. And however, you give your full name, Mr. So-and-so.
Devi Vaitsalya.
Vaitsalya Patha. So-and-so. Appearing so-and-so from the chamber of
Mr. Deas is found, but in Vakalatnama, his junior's name are there.
from the chamber of Mr. Devasis Potta counsel appearing before this court submits that he doesn't have Vakalatnama in the present matter.
In the Vakalatnama, Mr. Devasis Panda's name is also not there, but his junior's name is.
Doesn't have Vakalatnama in the present matter. However, at the same time, he submits that he has already prepared the matter to argue. Therefore, I am appointing Mr. Ratho as amicus curiae to assess the court. Assess the court after obtaining assess the court. He has argued the matter at length. Argued the matter at length. ठीक है. Judgment reserved. ठीक है. पैराग्राफ 1
18. This is the appellant has convicted under section 324 of for a RI for 1 year and fine 1,000 rupees. In default 3 months.
Yes. Only one appellant?
Let's see.
Yes. Hmm.
Let's see, the allegation against the accused is the accused person asked 20 rupees to the deceased. When the deceased was denied to pay him the same, the accused assaulted the deceased by means of knife on his left thigh and there and threatened him that if he would not pay the same, he would kill him. After that, the deceased reporting about the incident to the some other people in locality. Then deceased went to the house of the accused
Yes.
to complain about the incident to his parents.
Hmm.
On the way, the accused chased to the deceased.
Hmm.
After next day, next day morning, the dead body of the deceased was found near the house of accused. This is the allegation, Lordship.
Okay.
Lordship, the statement of the PW1, Lordship. PW1 is the informant of the
You were initially charged for which offense?
302, Lordship.
302.
Two.
Okay.
Then after judgment, the appellant has convicted under section 324, Lordship.
324. Let us see. Yes. Who is eyewitness?
Let's say there is no eyewitness. Let's say the PW2. Let's see who is a hostile. Let's see.
The eyewitnesses are Kuam Panadukan,
Hmm.
Malik,
Bhima Malik.
PW?
Malik.
Two
Eyewitnesses.
ସିଏ କହୁଛନ୍ତି କି ସେମାନେ ଯେତେବେଳେ ଏସବୁ ଇନସିଡେଣ୍ଟ ହେଲା କି ସେ ତାକୁ ପଇସା ମାଗିଲା ସେମାନେ
2, 3
and 5.
Okay. Let us see what 2 says. Nando Pratap Kumar. Okay.
Two lordship, the Bipin Malik lordship.
Yes, read it. Relevant part. About 5 minutes after arrival of Dari, the accused came there.
Thus taxed Dari to pay him rupees 20. Dari refused to pay the money, stating that he had nothing to pay to the accused. Then the accused gave a knife blow on the left thigh of Dari Malik, who sustained bleeding injury.
Dari showed us the injury, saying how far.
Let us see the doctor. Who is the doctor?
Doctor lordship, PW9 lordship.
9. And everybody has seen that he has given a knife blow, isn't it? And death is because of what? PW9.
Doctor କହୁଛନ୍ତି କି shock and hemorrhage. The cause of death due to shock and hemorrhage. Para 2 lordship. Probable cause of death due to shock and hemorrhage due to assault leading to rupture of liver, spleen, and left kidney by means of a hard and blunt object. In cross-examination, para 4, it cannot cause an abrasion.
The use of knife by the sharp edge either cause an incise or puncture wound, but it cannot cause an abrasion. The rupture of liver, kidney, and spleen can only be possible at the time if the injured falls on a height of 300 feet. But that is not ordinarily possible by fall, especially when some circumstances was given. So this is, and what about the other witnesses have said?
Other lordship, those who informed to the informant, he was a hostile lordship.
Yeah, hostile doesn't mean that you throw their evidence. All of them have said knife blow.
Knife.
Even.
କି ସେ ମାଗିଥିଲା 20 ଟଙ୍କା ସେ ନ ଦେବାରୁ
complain before.
PW, let's say PW8 who is the adopted son of the deceased, let's say.
One issue we are focusing, issue, we complete that issue, thereafter we will go to second issue. We are on the point that eyewitnesses have seen that he has given a blow that is in thigh by a knife. Okay? Whether that blow is the cause of death or not, that we are looking at that. See what eyewitnesses have said. PW2 has said that he has given a knife blow. What about 3? Accused pierce a knife in the left thigh, causing injury. Okay? PW3 also says that. PW5.
Same knife blow.
Same knife thigh blow. Okay? But PW9, the doctor says the death is caused because of
shock and
rupture of liver and all. And these injury, rupture of liver and the other part, spleen and all, and kidney injury, rupture in the kidney.
After this knife blow, the deceased
went to the house of accused.
There are the deceased went to the house of the accused to his parents that the
complaint
by means of a knife. There some quarrel also took place.
There other people might have
seen
no
what
what
happened
was
inside
seen.
the house.
Okay.
Might have been assaulted there.
That's the reason 324.
324.
Because he was charged with 302.
302, but no eyewitness to occurrence, and the doctor has not stated that it is sufficient in the ordinary course of
Yes, I know, I understand. Because that blow is not the reason for. But why should you disbelieve 2, 3, 5, and 9? 2, 3, 5, and 9.
That's a two who is the informed to the informant. And say informant को जे inform कर दे से कौन सी to hear the noise, I looked at the house of the accused and saw accused and his father pushing the deceased towards the rasta. To see this, I went home thinking that the father of the accused might be succeeding the matter.
2, 3, 5, and 9.
In the cross-examination, PW2 stated on the night I did not disclose the incident which had taken place in my presence to anybody, including PW1. I did not run the, I did not
It's all right. Proceed.
matter to the police, even if the distance of the outpost is 1 kilometer from my village. I did not intervene while the accused and the deceased were quarreling for 20 rupees.
Yes.
Then he stated that the injuries caused on the thigh of the Dari was a small scratch injury.
Scratch injury.
Scratch injury.
Okay. But the use of knife is it is recovered?
Yes.
Knife is recovered or not?
I will. PW10 I will.
There's still knife recovery.
PW10 cross-examination. PW1 did not stated before me that Bipin told him that he had seen Pradeep and his father both assaulting Daria near their house. And PW3 Abhi Malik did not stated before me that he saw accused causing knife injury on Daria's left thigh.
Then also. Then. Hmm.
Then he stated that Daria suddenly rose from the spot and near the pan shop of Kua said that without any reason Nanda had caused a stab injury on his thigh. I examined PW5 Bhimsen Malik. He stated before that he has present near the game of cats where accused caused a bleeding injury on the thigh of Daria. ସେ ଯେତେବେଳେ ଖେଳୁଥିଲେ ସେମାନେ ସିଏ ଯାଇକି ଡିସି ଯାଇ ଦେଖେଇଲା କି ମତେ ବିନା କାରଣରେ ଆକ୍ୟୁଜ ଇଏ ଯୋଉ ଷ୍ଟାଫ୍ ଇଞ୍ଜୁରି କରିଛି.
Knife was not recovered.
Not recovered.
Yes. All right. Yes. What is your point you want to argue?
Point, let's see, there is no eyewitness then the accused the deceased was dead, the cause of death.
You want to convert it to 302.
No, Lordship.
Then you have been convicted 324. Consented there.
There PW7 Lordship is the accused adopted son Lordship. PW8 जो deceased adopted son. The cross examination coach he did not stated before the police that Monzu told him that the accused threatened her to kill him and his father. Then then she should marry him. ଯଦି ସେ ତାକୁ ମଞ୍ଜୁକୁ ମ୍ୟାରେଜ କରିବାକୁ ଯଦି କରିବ ତାହେଲେ ଦେନ୍ ସେ ତାଙ୍କୁ ତା ବାପାକୁ ଆଉ ତାକୁ ମାରିଦବ ବୋଲି କହିଥିଲା, କିନ୍ତୁ ସେ ଜିନିଷଟା ସେ ଡିସକ୍ଲୋଜ କରିନଥିଲା ତା ବାପାଙ୍କ ପାଖରେ କିମ୍ବା ପୋଲିସ ପାଖରେ.
Yes.
Then there
He is attempting to argue. Otherwise, he have been asking for adjournment every time. He arguing, give full chance. Let him argue full.
then
Let him argue to his satisfaction.
Then the accused did not threaten him over his love affairs with Manju. Manju is the daughter-in-law of the deceased.
You structure your argument. What are the points and how you are taking you first structure. Whether according to you 324 is not made out. First you impress upon the court that 324 is not made out. What is the ingredient of 324?
Let's say knife was not seized by IO.
Okay, that is one point. Next, what are the ingredients of 324? To attract 324, what are the ingredients? You first read the provision, IPC. And all these ingredients are attracted in this case or not. That is how you have to read.
324, that's voluntary causing hurt.
You have been convicted under 324? Just see now. Read it.
Voluntary causing hurt by dangerous weapons or means. Whoever, except in the case provided by section 334, voluntary causing hurt by means of any instrument for shooting, stabbing, or cutting, or any instrument which used as a weapon of offense is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to human body to inhale, to swallow, or to receive into the blood, or by means of any animal shall be punished with imprisonment of either discretion for a term which may extend to 3 years, or with fine, or with both.
So what are the ingredients?
Ingredients, let's say the cause of death by means of fire or any heated substance, and used as an instrument of shooting and stabbing or cutting.
So you have used it, knife.
Mm.
That first is satisfied. Second is any injury, either it is simple, grievous, whatever. If you have used the weapon, deadly weapon, causing injury,
Injury.
324 comes. If you have only a simple injury without having a deadly weapon, 323 comes. And with the injury with deadly weapon, grievous injury, then 325 comes. Isn't it? So now you 324. 324, all the three witnesses have said that you have used a knife and they cause a blow in the thigh. And doctor also finds that injury in the body of the deceased who has died. But doctor says that that is not attributable for the cause of the death. That injury is not attributable because the death is because of the kidney, liver, and spleen
and
rupture. That may not be the attributed to the injury which you have caused. So that's the reason trial court says no, it is a case of 324. It can't be a case of 302. Otherwise, it is a case of 302. And Mr. Panigraj, what he says, is correctly saying that. But after this incident, which is after knife blow, he went back. There are something happened which nobody has seen, and that is the reason for the cause of death. Since nobody has seen, no evidence has come on record. So the trial court is correctly convicting you in 324 instead of 302. This is the whole case. How to get out of it? With the adopted son or no adopted son, those things are immaterial. You have to see eyewitnesses account and the doctor's evidence. It's straight away corroboration. And let us see the reasoning of the trial court. Reasoning of the trial court. Whether the reasoning is correct or it is not correct. See why you have been convicted for 324. If you read para 7, it deals whether the injury caused by you is the reason for the rupture in the liver, kidney, or spleen, which is the cause of death. And it concludes saying that no, that is not the reason. Now come to page para motive part is there. Motive is there. Para 10. Come to para 10. Now read it. Read para 10. So the
Para 10, that is, so far the first conduct does not lead to the inference that it was the accused who assaulted the deceased in order to kill him, with as regards the conduct at the house of the accused, as I have already stated that PW3 and 5
heard a
quarrel, but did not see what happened in the in course of the quarrel. PW2 alone saw the accused and his father manhandling the deceased. The learned public prosecutor strenuously argued that the fact of manhandling of the deceased would show that the father and the son, with a view to driving away the deceased from their home, pushed and assaulted the deceased, and in all probability, in so doing, the present accused might have dealt several fist blows on the severe fist blows on the abdomen and the chest of the deceased.
Might have been given.
Might have.
Yes.
Which result chest of
The latter
deceased,
stage.
which result in the latter's death. These two are faced a conjecture to make presumption as suggested by the Lawrence public prosecutor, the eyewitness PW2 has not seen the actual asset. The Lawrence Counsel for the defense argue with reference to the evidence that it was impossible for PW2 to see anything happening near the house
Of the accused.
near the house of the accused while one was proceeding on the public road. So PW2 is not at all a dependable witness, accepting for the time being that all that PW2 has stated in is true. Would it at all be possible for anybody to say that it was accused who dealt fatal blows on the abdominal area of the deceased? The answer to the question will be it cannot be. In the affair, it is stated that the informant PW1 suspected Babaji alias Brajakishore Swai and his son Pradeep Swai had killed Daria. If the suspicion is such, then
Then
obviously two persons together must have caused the death by assault. So whatever whether the accused dealt blows which killed Daria or whether his father Babaji and alias Brajakishore Swai dealt the death blow is again a question of a dilemma. Both the accused person
after investigation.
After investigation, the charge sheet was filed against both the accused person for the charge under section 302 34 of IPC. Obviously, it would mean that both the accused person in furtherance of a common intention had dealt fatal blows resulting in the death of Daria. It will be worthwhile to note that my learning prosecutor while trying Babaji alias Brajakishore Swai in investigation number 367 of 14 of 1995 found that there was no conclusive proof to establish the guilt of the accused. So he acquitted the accused Babaji alias Brajakishore Swai. Of course, the finding and the evidence ST case number 367 of 14 of 1995 cannot be used for any purpose in the present case. But my aim is to assess.
Yes. What you understood? What is this case? ST case 367 of 14. What is that case? Have you understood what is written? What is that? What is that case?
କହୁଛନ୍ତି କି fatal blows
No. What is this case? ST case number 367 of 14. Why this case is referred to in this paragraph?
There is no found conclusive proof to establish guilty of the accused.
Which accused?
Babaji Charan.
Who is he? Who is he? Who is Babaji? In this case, how many accused are there? Two. And just see the judgment. This judgment is for whom?
Accused, the appellant number.
Nanda. And what happened to the other accused? And who is that man?
The other accused lordship, the appellant's father lordship.
Who? What happened to him?
Se କହିଛନ୍ତି କି ତା ଘରକୁ ଡାକି.
No. Has he been convicted?
No.
Then what happened? What happened?
Lordship, the Babaji, the father of the accused, has acquitted in this case.
Which case?
ST case number 367 of the.
That's what I was asking you. While reading, you see, he was a separate trial was conducted for him. Might be this client, this accused might have absconded or something.
Yes.
The trial was splitted up, and Babaji faced the
Baba.
trial. He has been acquitted by the predecessor judge.
Yes.
The same court tried Babaji, this ST case number 36714, and acquitted him for 302.
30.
Okay. That is how you have to read the judgment. Now you understood. Now, what is wrong in this reasoning? I don't find any wrong in this. You should be happy that it was not, enhanced. Yes, Mr. Panire, we will give you. That's the only thing. I'll give you.
Yes.
Okay.
That's it.
You undergone period undergone because 302 was there.
Mm.
You might have undergone a substantial Just see, undergone.
See, let's see, the accused arrested on 1/2 of 1995. Then
You might
This year,
undergone for For arguing a criminal appeal, you have to read each and every line. Each and every line, everything has a meaning. Undergone period. Because it was a case of 302 initially, he might have been taken into custody. Just see UTI period.
Let's see, the accused released on bail 28/9/1999.
Arrested?
Arrested on 31/2 of 1/2 of 1995.
1995.
Let's see.
And date of
Released on
incident?
bail,
Date of incident?
2/2/95. Date of
89.
appearance, sorry. Date of occurrence 31/1/95.
31?
1/95.
1/99. তারপরে দিন আর দেখছি বেলটা রিলিজ অন বেল
When was he arrested? Because the para 3 of PW10 says that I arrested the accused Babaji Swain, forwarded him to the court. Accused Pradeep Swain was not traced. I searched for him on 1/2/95, so and so many dates, and in several other dates. But having failed to arrest him, as he was concealing his presence, I filed the charge sheet. I placed the charge sheet, showing him as an absconder. But when was he arrested? Let's see the order sheet.
2/7/1998 2/7 জুলাই 2/7/1999 2/7/1999 তারপরে তুমি সরেন্ডার করে কি বেল নেই নেক্সট এটা পরে ସେ ଆରେଷ୍ଟ ହେଇଯାଇକି ଇଣ୍ଟରନ୍ ଦେଇଛି ଆରେଷ୍ଟ ହେଲା ପରେ ଡିଟେଲ 2/2/95 ଗଲା ପରେ ସେ ହଉଛି ତାପରେ return till 28 ନା from return till 4/5/95 then ହଉଛି ତାପରେ ହଉଛି 28/9 ଦୁଇ ଦୁଇରେ ଫରୱାର୍ଡ ହେଲା 2/2 ଫରୱାର୍ଡ ହେଲା 55 ଫରୱାର୍ଡ ହେଲା ତାପରେ ହଉଛି 28/5/1995 5/1995 ହଁ
24 दिन ପାଇଁ
interim bill है
interim bill ଚଲୁନି interim bill
ଆଜ୍ଞା
ତାପରେ next କଣ କହିବେ
ये बाबा जी ନା 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 ଆଜ୍ଞା ସେଇ ନଣ୍ଡା ତ ସେଗୁଡ଼ା ହଁ ନଣ୍ଡା ସେଗୁଡ଼ା ନଣ୍ଡା ତାପରେ ଏଗୁଡ଼ା ତ circulating on citizen just the person bail on bail ID एक 5 मिनट चला
split up ହେଲା।
ये 4 month ରହିଛି
କେବେ ସେ arrest ହେଇଛି
ହଉଛି ଏକ ଆରେଷ୍ଟ ହେଲା ଦୁଇରେ ଫରୱାର୍ଡ
abscond ଥିଲା 25/9/95 କେସ୍ split up ହେଲା।
ତାପରେ ସେ ହଉଛି ଏମିତି ହୋଇଗଲା 80% on bail on bail ସେଟା ହଉଛି
ଆଉ ସେଟା ବାବାଜୀ ସ୍ୱାଇଁର କ୍ୟାଲେଣ୍ଡର ଷ୍ଟେଟମେଣ୍ଟ ତମେ ଦେଖୁଛ।
ନା ନା ନଣ୍ଡା alias ପ୍ରଦୀପ ସ୍ୱାଇଁ ଏଠି
ନଣ୍ଡା alias ପ୍ରଦୀପ ସ୍ୱାଇଁ।
ପ୍ରଦୀପ ସ୍ୱାଇଁ ହଁ ଏଠି
କଣ ଲେଖା ହେଇଛି
ନଣ୍ଡା 80%
Date of occurrence ହେଲା
ଡେଟ୍ ଅଫ୍ ଅଫର
ଠିକ ଅଛି ତାପରେ
31
ନା ସେଟା ଭୁଲ ଲେଖା ହେଇଛି।
date of occurrence 5/6
କମିଟମେଣ୍ଟ ହେଇଛି 5/6 31 ହଁ 31/6 31/95 ଅଫର ଅଛି
You would get anywhere, anything.
No, this case was split up.
लिखित दिन कष्ट
Just see the case diary, case diary also. Case diary. He has filed a bail bond on 5/8/96. 5/8/96. SDJ. Pradeep Kumar Swai.
The case was split up on 25/9/1995. 16th, 16th September 1995. That letter is there of the SDM to the Sessions Judge Cutter at page 256.
ଏସବୁ convicted ହେଇଗଲା ପରେ ସେ ଲେଖୁଛି ସରେଣ୍ଡର କରିଛି 28/9/19 ହଉଛି ରିଲିଜ ବେଲ୍ ଏବଂ
He was granted bail on 9/8/96.
On 5/8, probably he surrendered in court.
9/8/96 bail. Bail. Okay.
After completion of the trial in first
Right.
case, he surrendered. The two
Ah,
accused
by-
were acquitted.
by ASJ Jajpur. This is the bail date. So he surrendered, I think, 5/8/96
5/8/1996.
and 9/8 is 4 days only. Only 4 days. Then PO. I was searching if he had already undergone the entire period. There is no question of giving PO, na? So that is the reason I was searching. Yes,
Item 25 is a small matter.
25, huh?
Item 72 losses.
Hmm?
Item 72 is losses is small matter. 6 months.
Which one?
72.
25 is 2002 and
Yes, sir.
71, 72
Yes, sir.
is
Conviction is for 6 months.
6 months also.
And out of 21 accused, already 6 are dead.
what is the offense?
Offense losses 147, 323, 337, 149 of IPC loss.
72, na?
Yes, loss.
Oh, so many people.
Yes,
6 month sentence.
yes, loss.
I give PO and finish it up, yeah.
Yes,
What is
yes,
unnecessary?
sir.
72 the PO. 72, na?
Yes, loss.
7.
Huh.
There is a
Lordship, I am appearing from for 11 apparent lordship. Ma'am is also appearing.
No, please give. Your Vakalatnama is there?
yes, sir.
Both of you?
My power is not there, lordship. It's a matter of 2010 lordship. That time I was reading in 10th lordship.
Then Prasad then now 2009.
No, no.
Something is there.
Why I ask you is, if your Vakalatama is not there, then I'll appoint you as an amicus.
Bakaran is there, lordship.
There, na?
Your name is not
No,
there.
my name is not there. My name is not there. Lordship.
So,
It's there.
for how many accused?
11 lordship. 3-year died lordship.
You are appearing for which accused?
CRL 44.
44 of 2010 lordship.
44.
No, 44, but which accused you are appearing?
Panchanan
number?
Sahu lordship.
Accused number?
One.
Only one.
No, sorry. Two appeals lordship. I am appearing for.
Now, first let us see who has died.
Yes, lordship. Panchanan Sahu lordship.
Hmm?
Panchanan Sahu lordship.
There are 11 accused appellants. Poncharan Sahu.
Yes,
Number?
One lordship.
One. Died. Abated already? Already abated?
No lordship. No lordship.
Where from you got the information? Died.
No, their information.
Report is there.
Yes. Report is not. All are alive. That is my report. But they are saying that 1, 2, and
11 is died lordship.
That is their.
I got instruction from my team lordship.
But
That is not our information. Our information is all are alive. No, I'm all are and all are alive, and now they are staying at this.
there are two appeals, yeah?
Two appeals also.
In 44, you say Pancharan has died.
Panchanan died and Nabbaghana Sahu lordship, appellant 2 lordship, and appellant 11 lordship. Rebanta Sahu lordship.
11.
11 lordship.
You are appearing in this matter.
Is matter.
The problem is I can't record your statement in amicus. If you would have, then Vakalatnama would have been there, I could have recorded your statement and await but you don't have any Vakalatnama also. What about, you are appearing in 47? Anybody died there?
Yeah, the government has the record.
Huh?
Sir has the record
Okay.
who have died.
Let us see 47 to key mola. First item. First item, everybody is. What about second item?
Second item.
Second item. Who are dead and one is unprecedented.
Who is died here?
Second item.
Hmm?
Indramani and Parsuram Das.
Indramani died and
Parsuram Das also died.
Parsuram Das is
2 and 5.
5.
Judgment 2 judgment.
Missing the mention.
And Guna Das, whereabouts is not known.
19, no, judgment of 19.
Guna Das, 7.
47 to लिखो
7. Not
47 to लिखो Mr. Mr. Awad, the Council of District has filed a report dated 23/2/2026 by the IAC of Otakura, is Intralia, stating that appellant number 2, Indramani Satpathy, and appellant number 5, Parsuram Das, is already expired. The report is taken on record In view of the said report, the appeal qua appellant number 2 and 5 stands abated in the absence of an application under section 394 CRPC, either by the LRs of the deceased appellant or by their next friend. The appeal only survives qua appellant number 1, 3, 4, 6 to 9. 6 to 9. Okay. And our second item is 47. Madam Karnani. In 44, you say that then counsel appearing for the appellants. That means that out of 11 accused persons, 11 appellants, appellant number 1, 2, and 11 have already expired. However, no such report has yet been obtained from the State Council to ascertain this aspect. Hence, the State Council is directed to verify the factum of the death of appellant number 1, 2, and 11 by Tuesday, next Tuesday. Okay. Which police station is this?
Patkura PS. Patkura PS.
Patkura, no?
Yes, Lordship.
Patkura, you just write it today?
Yes.
Tuesday, I'll take it up.
Yes.
I'll await that. Both the matters, top as listed there in the category of report. In the category of report. Today only you do it. I don't know, both the matter I'll finish.
My matter is 25.
20?
For 6 months conviction, for 6 months.
23?
25.
25. Yes. Offense?
For 294, 1 month.
Hmm?
For 294, 1 month. For 354, 3 months. And for 3 SCST, 6 months concurrently.
3 SCST is made out.
Yes, loss.
Let us see, because 3 SCST is there, then no question of probation. Otherwise, I would have given probation.
Therefore, I'm saying you lost it in and you have a glance to the one compromise petition has been filed, which was subsequently.
No, compromise will not help because SCST is made out, then let us see.
3 SCST the investigation sub-inspector. That's the busy.
Show me that.
Yes,
Show me that.
I have taken that ground.
No, not ground. Show me the IO. Who is IO?
IO PW8.
PW
8.
8.
Sub-inspector.
As posted is SI police.
ठीक है? Sub-inspector.
Registered the case. So charge sheet कहाँ है? Where is charge sheet? Where is charge sheet? Here. Charge sheet file form for. We send file form for. Yes, charge sheet is filed by SI police. 2002 case. When the FIR was registered?
FIR date was.
No, here the occurrence is 1994.
94. 29/5/94.
28/5/1990.
Oh, 95 the rule came into force. When the by the time the charge sheet was filed, 10/10/95 was the charge sheet.
It came into force on
31/3/95.
1995.
Charge sheet was filed on 10/10/95.
3 SCST goes.
3 SCST goes, then rule 7 31/3/90 5 charge sheet on 10/10/95 by SI of police. That is PW?
It is the, I know is PW8.
PW8.
Okay.
SC/ST, I'll take out SC/ST
In-
and for other offenses, PO.
Informant also. Informant also is fine. काफी नहीं informant PW shop. PW shop also.
Thank you.